Turn to M3 and Karen B for this week's episode of Comply on the Fly. You'll get quick and timely answers to the most common employee benefits compliance questions so you and your business can keep moving ahead. Please note this podcast and the contents herein do not constitute legal advice. Please seek the advice of counsel for any benefit compliance-related implementation, guidance, or strategy.
Hello, everyone. I'm Karen B. And the Comply on the Fly question of the week is, what do I do if an employee qualifies for both federal FMLA and leave provided by state law? In general, federal FMLA and leaves provided under state law should be run concurrently when an employee qualifies for both. That is the simple answer. But of course, that requires you to determine eligibility under both federal and state law requirements. For instance, federal FMLA law requires that an employee, 1, works for a covered employer, 2, has worked for such employer for a total of 12 months, and that 12 months does not need to be consecutive, 3, has worked at least 1,250 hours over the previous 12 months, and 4, works at a location where an employer has at least 50 employees within a 75-mile radius. This last one, number 4, is very important because many times I hear employers say they are not subject to FMLA. However, if they have at least 50 employees in total, then they are subject to FMLA and must provide the posters and have a policy. However, if they don't have any employees that are in a location within 75 miles of a location that has 50 employees, then they simply don't have any eligible employees. Okay, so once you've determined that the employee meets the federal requirements, then you must look at the state eligibility requirements. Wisconsin, for example, has a separate leave law, and that law does not mimic federal FMLA. Eligibility requirements for Wisconsin have to be looked at separately under Wisconsin leave for the employee. First, that employee has to work for a covered employer, which in Wisconsin is 50 or more employees. 2, that employee has to have been on the payroll for that employer for 52 consecutive weeks. And 3, that employee has to have been paid for work for at least 1,000 hours in the last 52 weeks, and that would include holiday pay and sick time. Another example of state law is Illinois, which offers several different types of leaves, such as the Family Military Leave, the Victims Economic and Security and Safety Act leave, the Child Bereavement Leave, and the Employee Sick Leave. Illinois employers have to determine if there is eligibility for any of these leave provisions and run them concurrently with federal FMLA if applicable. And remember, if leaves under federal and state law run concurrently, the provisions that are more beneficial to the employee will typically prevail. And that is your Comply on the Fly question of the week. Thanks for tuning in.
What's on your mind? If you have a pressing compliance question, send it to askkarenb@m3ins.com. We'll do our best to cover it in an upcoming episode. You can now follow and subscribe to Comply on the Fly on Spotify, iTunes, and Google Podcasts. Make sure to tune in next week and encourage others to join us.